According to the cloud. Okay. Good afternoon to this small but hearty bunch of folks who've come to attend our session. This is the session of what arbitrators should expect from advocates and what advocates should expect from arbitrators. If this is not your flight, and you should go back to the counter and find out where you belong. Very quickly, let me give some my fellow participants. We have with us two fine arbitrators, Jacquelin Drucker, who has 30 years of experience serving as an arbitrator in labor, employment, and complex commercial disputes. She has offices in New York and Ohio and works in a wide variety of a range of industries throughout the country and abroad. Since the 1990s, she has taught for the Cornell University School of Industrial and Labor Relations and the Scheinman Institute on Conflict Resolution. She's a member and former governor of the National Academy of Arbitrators and recently completed service on the board of directors and council of the American Arbitration Association. Arbitrator Drucker is also a former chair of the NYSBA Labor and Employment Section and is a fellow of the College of Labor and Employment Arbitrators. Also on the panel is Melissa Biren. Having been in front of her, I can tell you that she's an accomplished arbitrator, mediator, and a lawyer with over 30 years experience in labor and employment matters. Her full-time ADR practice concentrates on resolution of workplace disputes in the public and private sector, serving as an arbitrator and mediator in labor and employment cases involving diverse disciplinary, contract, statutory, and common law issues and claims in a broad range of industries. She's listed in local, state, and national rosters of arbitrators and serves on a variety of permanent panels. And I can tell you, I looked at all the different panels and there are plenty of them, so you must be very busy, which is good. Member of the National Academy of Arbitrators and currently serving its Board of Governors. She's also a member of the Executive Committee of the New Jersey State Bar Association Labor and Employment Section. And she, among her publications, is a book that I've used, Discipline and Discharge in Arbitration, along with Norman Brand. She is admitted to the practice of law in New York, New Jersey, and Connecticut. And as for myself, I have been practicing labor and employment law for 40 years. And I am also an arbitrator on the AAA panels of the Employment Litigation Panel and the Multi-Employer Withdrawal panels. I have served also as an independent investigator. I'm on the executive committee of the Labor and Employment Section of the State Bar, and I'm admitted in a variety of different states. So the purpose of this panel is to just discuss what we as arbitrators and as advocates really want to see in the context of arbitration. So what I'd like to throw out, and maybe we'll have Jacquelin, if you would start, tell me what, as an arbitrator, what do you expect from advocates preparing for an arbitration? And you can discuss any distinctions you have between the different kinds of arbitration. Principally, though, I'd like you to answer that question in the context of pre-arbitration or pre-hearing. What are the types of things you think advocates should be doing that make your life easier or a more productive arbitration?
Well, when we're talking about pre-hearing, and I think as you suggested, we have to always draw a distinction between labor arbitration and employment arbitration. Labor being arbitrations under collective bargaining agreements, and employment arbitration being those practically everything else that can be executive contracts or those employment agreements that are arbitration agreements that are part of applications for employment and so forth. So employment arbitration, runs the gamut from wage and hour claims to discrimination actions relating to applicants for hire, all the way to senior executives and financial services people, in which millions and millions of dollars are at stake. And usually it's the employee suing the employer, but not always in employment arbitration. It sometimes may involve a non-compete, anti-poaching, and provisions such as that. So in terms of preparation, most of the heavy lifting in employment arbitration is done in the pre-hearing phases, as contrasted with labor arbitration, where our parties are going to be a union and an employer. And there, we hope that the preparation and the preliminary work will have occurred in the course of the grievance procedure. Information will have been exchanged, positions will have been examined, and so by the time the parties get to arbitration, they know what the evidence is that they want to present, what the other side will be expected to present, and they will have kind of crystallized or identified the issue. That's not always the case, but labor arbitration doesn't have within it a structure for that, those sorts of things to be fleshed out with the arbitrator's involvement in advance. So in terms of preparation prior to the hearing by advocates in labor arbitration, if they can talk and just work through some of the basics, and we've seen more of that with the use of virtual platform hearings because it's been necessary to sometimes exchange exhibits in advance, and a little bit more of a focus on conferring to develop joint exhibits. And that is very helpful, and that helps move hearings along and helps us continue what is, I think, the diminishing experience of the one-day labor arbitration, because when there are surprises, one party needs time to deal with evidence they didn't expect, or if there are issues that were not expected, arbitrability challenges that aren't made until we're all in the hearing room. Those things very often can cause what could be a one-day hearing to spill over into an additional day, and then you very often are talking about months and months of delay when you put everyone's schedule together. Very different in employment arbitration because we have specific rules and structures that provide for pre-hearing conferences. We have a worksheet, if it's a case through the American Arbitration Association, that goes to the parties, and we like to see counsel having conferred, and usually they are instructed. If it's a AAA case, AAA tells them. If it's not, I will tell them, and I think Jed, you and Melissa do the same. We instruct the parties that these are the things we'd like you to talk about before you come to the first arbitration management conference, so they can work out their expected timetable, what they want in terms of discovery, if there are any disagreements, and what they expect. So in terms of pre-hearing preparation, I think those are the things that we like to see, and I think you could say we expect it. Certainly in employment, we expect it because the rules provide for it, the structure provides for it, and in labor, we expect meaningful use of the grievance procedure prior to arbitration.
Thank you. Melissa, I'd like to get your thoughts on that, but as Jacquelin was talking, I thought in the context you're speaking of the pre-hearing, whether it's labor or employment, your thoughts on how the parties could help you in terms of by knowing what procedures there are in whatever organic document we're talking about, whether it's the collective bargaining agreement or some employment, and in the employment agreement with the arbitration provision, and in the labor context, the importance of thinking through the submission before the start, as it relates to one of the most important things we have to deal with is the question of what's our jurisdiction? What are we being asked?
I think, yeah, defining the issue in a labor case is one of the most important things, obviously, because it tells me what it is the parties are expecting of me. What's the question you want me to answer? Unfortunately, some parties come with that resolved and some parties don't. And you say, well, what will be the issue? And they look at you and they're, oh, well, in a just cause case, that's an easy one as a general rule. In a contract case, that gets to be a little more complex. And, I think it's helpful where there are disputes on that to bring that to an arbitrator in advance. I've had several cases like that where we've had conferences to discuss that, so we don't waste a lot of time at the hearing. In an employment case, generally, by the time we get it, if there's no jurisdiction, the court has addressed it, because very often those things go to court, and then someone, usually the employer, moves to compel arbitration. So you sort of have that arbitrability issue somewhat resolved. But there are still other issues that do come up as to whether something arises is encompassed by the agreement. And it is important, I think, for the parties to understand, what does the arbitration clause provide? What rules are in it? How do you select arbitrators? There's an awful lot in the contract, because the language, whether it's the collective bargaining agreement or an employer promulgated plan or an individual agreement, that defines our jurisdiction. So it is important for the parties to be very cognizant of what is provided. In a labor case, it's pretty straightforward for the most part. You don't get many substantive arbitrability arguments. It does come up on occasion, more so in public sector, I think, than private sector, because sometimes the rules on what is negotiable and subject to arbitration might be different. But I don't see many substantive arbitrability questions. I do see it on procedural issues, timeliness.
Well, I'll tell you, there's my thoughts from a labor arbitration perspective. I have seen careless submissions where, sloppy in the sense of, where, they typically write was he fired for just cause? And if so, what shall the remedy be? The problem in that particular case was that the contract provided for a very narrow range of remedies. And so after the arbitrator found that just cause did not exist and brought him back with full back pay and all the full panoply of remedies, the employer moved to vacate on the grounds that he didn't show a fidelity to the contract with respect to the remedy, and the court denied the motion to vacate because they said, your submission said, and what shall the remedy be?
Correct.
And so it's very important to make sure that you've thought through the submission. And of course, in many cases, the parties won't agree, right? And then the arbitrator has to figure out what to do.
Well, and one of the problems you have in a labor case is that the first documents that go out that define the grievance are prepared by people who are not necessarily skilled at doing that. And some contracts have very specific language. You have to identify the contract clause. You've got, and that becomes, to me, it's a notice requirement. You've got to be sure that notice is provided of what's going on. Obviously, if the contract has very specific requirements, you've got to look at that. But that's part of the problem in labor, is that it doesn't get to people who really know the collective bargaining agreement well enough to articulate it in a way that, that you would hope. Sometimes at the early stages where they're initiated by a shop steward or sometimes by an employee. So that becomes a little bit more difficult, I think. But you're right, the submission does make a big difference.
Jacquelin, recognizing that, especially in labor arbitration, not so much in employment arbitration, the parties, there are many cases where the arbitration hearing is, the parties are represented not necessarily by attorneys, but, for example, a seasoned business agent, or on the union side, a VP of HR or a director of labor relations on the other side, if you're lucky, on either one of these sides. And of course, it's slightly different. But at some point, they have to help you, right, to give a good submission, regardless of whether they're lawyers or not, because theoretically, at that juncture, you've got sophisticated people at the hearing.
Right. Well, can we talk a minute about at the hearing? Because to me, the structure of arbitration and labor arbitration is somewhat inspiring when we see non-lawyers handling cases and the effectiveness with which non-lawyers can present cases when properly prepared, when they focus and when they're trained. I always say there isn't that much they teach you in law school that actually helps you present a case in arbitration. And what I find in terms of preparation, to bring in the concept of preparation in terms of preparing for the hearing, especially for those who aren't lawyers, is always understanding the difference between fact and argument. And we have a sophisticated group with us here today, but for people who might be viewing our discussion on the video, I think it's useful to remind advocates that in their preparation, they should be aware that arbitrators are what John Sands calls they have curable ignorance. We generally are ignorant about the exact work that's done, maybe even what the company does. And to provide us with a little background that helps put everything in context. And one of the most critical things, and the things that non-lawyers pick up almost immediately when they begin to focus on it, in addition to the manner in which exhibits are entered into evidence through, the logical process, the minute that people become familiar with the way in which we do that and are prepared for it, they see the structure and the balance and the fairness that goes into that. But in questioning witnesses, that's one of the points of preparation that I always like to stress, and I hope to see, and it's tremendously helpful, I think, to us as finders of fact, to carefully construct direct examination questions. And the reason I say that is because very often we hear leading questions on direct. And I think that's because advocates, lawyers or otherwise, know what the witness is going to say. The witness knows what they're expected to say. And not a lot of attention goes into the construction of the question. And it's arbitration, so they can lead, and that may be the case. But the responses to leading questions are not as helpful to us as fact finders as the open-ended question. And I say that this ties into preparation because sometimes it's difficult to construct a question that is not leading. And an example I have is from a case involving, this was a strange case in which an employee had been directed to wash the Jell-O in a restaurant case and had been disciplined for refusing to wash the Jell-O. And the question to the supervisor was, did you give him a direct order to wash the Jell-O? Okay, so the answer is yes, and you've got that little piece of information. But it doesn't help us as fact finders if there is some question about what was said, contrasted with the question of what did you say to him about washing the Jell-O? And the witness says, I told him, I've asked you nicely twice now to wash the Jell-O. It's the lunchtime, it's the rush, we don't have time for this, so I'm going to give you a direct order. I know you think it's gross, and it was, right? But he said, I know you think it's gross, but I'm giving you a direct order. I need you to wash the Jell-O now. And so you have that beautiful context and elaboration that then if the grievance says, oh, well, it wasn't clear they asked me, I didn't know I was required to, then it helps us as finders of fact. And the reason I say it takes preparation is that when the advocate is prepared with a leading question, and if the advocate is asked not to lead, it's hard, and it's especially hard when the arbitrator and the witness and the court reporter and the opposing side are all staring at the advocate while the advocate is trying to reconstruct what was one leading question. It might take two or three to be non-leading. And so just in terms of preparation and what is helpful, that to me is always high on my list.
In terms of a hearing, and then I'm going to ask Melissa a question. In terms of the hearing, at least from where I sit, once you get into the hearing, aside from, I hope you've prepped your witnesses so that, we're not sitting around twiddling our thumbs. I hope you know how to put a document into evidence, or at least let me help you. But the one bullet point that I'd like to put in is lack of civility. Let's try to be civil. Let's not interrupt each other. Let's not put in frivolous, ridiculous objections that, but putting that aside, Melissa, before we go on to what advocates should expect of us, putting your hat on as an employment arbitrator, do you prefer what do you prefer, just closing arguments? Depends on the case, of course, or do you want a post-hearing brief?
It depends on the case. I basically, my rule is, unless it's very complex where I really feel I need it, or it's gone on for a lot of days and it's helpful to have them put it all together, I leave it to the parties. It's the parties' process. And, if they tell me that they want to do written, that's fine. If it's a simple case, whether it's labor or employment, I'll look at them sometimes and say, are you sure? I don't think I need it, but I recognize that sometimes the client wants it. And so, they're doing what their client wants them to do. So for me, closing statements, I can go either way. If it's a complex case in an employment setting, almost always I have gotten written closings. I focus much more on an opening, because to me, an opening statement is critical, and too many people try to, they defer. I don't think that's appropriate. I am not the kind of arbitrator who will force it. I know some people who will. I want to hear an opening. I won't do that, but I think it's really important to set forth the context that you want me to be listening to the evidence. Now, in an employment case, if I have a pre-hearing brief, I don't need that. They've done that already in the brief. I've read the brief. I'm aware of everything going on. In an employment case, I have far more context because I've been working with the parties on all kinds of things, discovery issues, possibly a dispositive motion. So I have much more familiarity with what's going on. In a labor case, we often don't. So openings are very, very important. Closings, they're important, but I will go either way depending on the parties. My own policy is not to insist on one thing or another. And if both parties really want to do it, do an oral closing, I don't want to impose that cost on them. Unless there's some reason, and perhaps there's one point that I want them to address. But for the most part, I respect their decisions on that, and they have to live with what they do.
So we're going to move on to another topic, which is what advocates should expect from us as arbitrators, both pre-hearing and at the hearing, and I guess after the hearing, depend on what our obligations are. Jacquelin, want to just sort of bullet point, and I'm going to have a follow-up question for you, but bullet point some of the things that you think advocates should expect from us as arbitrators.
Well, I think I know one of the things you
You need
Jacquelin,
your
hearing.
we can't hear you.
there we go. I knew I wasn't muted, but I had moved it up. There we go.
Okay.
I know one of the things you wanted to talk about, Jed, was disclosure. And I think that is an element of one of the critical things that the advocates are entitled to from us. And that is impartiality, fairness, judgment, etc. But impartiality, and with impartiality comes the appearance of impartiality, and sort of in furtherance of that are our obligations to disclose, and they vary pretty significantly between labor and employment arbitration. And by disclosure, I mean, and in the labor world, we actually have to define what that is, because it doesn't happen as often as it does in employment. We mean upon appointment, or if something comes up in the course of the hearing, disclosing to the parties some connection that we might have, present or past, to the advocates, to the parties, to the facts, etc. In employment arbitration, that takes the form, in my case, and I think for both of you, in every single case to which I am appointed. I do a fairly extensive disclosure, because almost always the advocates, the law firms on one side or the other, have appeared before me before, and those are things we are obligated to disclose in employment arbitration, so that the parties, before proceeding, we've been appointed, but then the question now is, now that I've been appointed, let me tell you, some of the things you might want to know. And new arbitrators a lot of times say, well, if I disclose this, it's saying to the parties, it means it may affect my judgment. And AAA, a number of years ago, changed the rules to specifically say that a disclosure should not be viewed in that way. It's just the arbitrator saying these are connections. Sometimes it's an explanation of why it is when we go into the hearing room or in a pre-hearing conference, one of the attorneys may indicate that they know us or have arbitrated with us before. In employment, that's something that needs to be disclosed. In labor, because the parties have an ongoing relationship, because collective bargaining agreements tend to have panels under them, the parties tend to have the same arbitrators hearing cases repeatedly, it is pretty much a given, and it is not and it is expected, or it's not surprising to a party that an arbitrator may have had cases previously with one of the law firms or one of the parties. So those aren't things in labor that we are really expected to disclose, but connections. I mean, I worked as a union lobbyist 40 years ago when I was in law school, and then I was with a management law firm. And even though that was 40 years ago, every case, labor or employment, that comes up involving either that labor union or that law firm or lawyers who were with that law firm and now are somewhere else, I always disclose that. And part of the reason for that is to protect the appearance of impartiality, so that if a losing party, and this is one of the things I always ask myself, or when other arbitrators say, should I disclose this or that? Say, if the losing party after losing discovers that you once worked, or your spouse once worked for this law firm, or that you had this connection to this union 40 years ago, does it cause them to question your impartiality and your judgment? And the fact that it's not disclosed, and the courts even say this, non-disclosure can give rise to a presumption of bias or presumption of partiality. So we get this out there, we get it all on the table so everyone knows about it, and at the beginning, so when everyone recognizes this and the arbitrator has made it clear, it gets that issue off the table because the parties have indicated that they're comfortable proceeding. And so I think part of the impartiality that the advocates certainly are entitled to expect from us includes disclosure, but disclosure needs to be handled within the context of the type of arbitration it is. And in fact, different rules and different codes of ethics apply to labor versus employment, and that helps shape the scope of the arbitrator's obligation. I tend to disclose more than probably required on the labor side and the employment side, but I think we all tend to disclose quite profusely in employment arbitration, because we want to make sure we get it all out there.
Melissa, obviously our advocates want us to create an atmosphere of fairness, and they want to believe that we're being fair. So tell me, what are some of the things an arbitrator can do to establish an air of fairness, to let the parties know that this will be handled in a fair and impartial way?
Well, I think, number one, you're controlling the process from both sides. You're making decisions based solely on the record. You're making rulings that are fair and consistent to both sides. You don't use first names with one side and last names with the other. Things like that just show that you are treating everybody equally. And also it's important that you give everybody a full and fair opportunity to be heard. One of the bases that you can be overturned as an arbitrator, you can be vacated, is if you fail to allow relevant information to come into the record. And that can be a tough balance, because you do want to make sure to let things in. On the other hand, arbitration is not a free-for-all, and some people think it is. And years ago, I think rules of evidence were less I don't want to say we do it strictly, but I use rules of evidence as guidance for reliability of evidence, right? That's what I'm looking for. I don't take things for what they're worth because the other side doesn't know what they're worth. And that can change from a 1-day hearing to a 2-day hearing because suddenly do they have to address something that was brought in that you took for what it's worth. Well, what was it worth? How do I know that? So I don't do that because I don't think that's fair to the parties. But I think in terms of fairness, it's the way you handle yourself and mostly your rulings. And I think it's a matter of also, you do get a reputation of deciding things based on the record before you. I mean, I could not tell you how many cases I've decided for one side or another. I don't track it. I don't know it. I don't care because every case is new. Every case comes to me and it has its own set of facts and you have to rely on that. But I think that's what I do. I try to make sure both sides feel that they're getting a fair shake, full and fair opportunity to be heard. But, if one side repeatedly ignores something going on, yeah, I mean, you're going to be ruling more in favor of one or the other. There's nothing you can do about that. You can't suddenly say, oh, well, I want them to think I'm being fair. So I'm going to change how I would handle that particular thing. We do have a question, Jed.
I'm sorry, who was the question?
Gary. You're muted.
Okay, and my opinion on the term take or a proposed document as accepting it pending whatever. I was taught long ago when an arbitrator said that they were just going to take it into the record and give it. Basically, it was just code for we're not going to give it any weight. And I still do the same thing as a hearing. As an arbitrator, when parties are very vehement about getting a document into the record that is there for the first time, no one has ever had a chance to respond or if never even seen it before. And I can make a quick enough judgment, I believe, that it has nothing to do with the issue at hand. And if it does not have anything to do with the issue at hand, then I'll normally just to move the case along and rather than get into arguments, I will just simply say, I'll take it for what it's worth. And I think advocates are taught that. I know that I worked for the Postal Service, APW, for a long time. I have done, I don't even know how many. I did regular panel cases. I've done over 700 as an advocate. If you include the expedited, the lower level, there's probably over 1,000. And I've taught arbitration for the APW. And that's what we've defined that particular, and heard many arbitrators make that statement to me, because I would try it as an advocate. Yeah, here's something we just found out about last night. And the Postal Service, and rightfully so, would object that.
Well, I think there's a difference between something found late and something having no value or a hearsay statement. But again, every arbitrator is different, and that's something advocates should know, that different arbitrators treat things differently. There are times, for example, if somebody brings in a ton of character letters, and we all know that we don't need them, they're just not relevant to what's going on. But I know that the grievant, for example, really finds that's important to them to have that in. I will say, I will take it, but I truly do not believe, I will be very honest about it, that it has, that it is not something that I think will be persuasive to me, but I let them know. I ask them to listen to what I'm saying so that they understand that sometimes you do have to let things in, but that you get it. You get their objection, you understand where they're coming from, but you're going to do it anyway, and not to worry, you don't need to do anything. I think there's a, I think it's sometimes it's a way for parties not to bring things in and bring in the proper competent evidence. And that's problematic, as opposed to something that may have happened the night before, to something where they don't want to bring the people in to be examined, for example. Well, you know, that's a problem, because I want to hear from those people. The other side has a right to cross-examine those witnesses. And if I simply take it for what it's worth, now some parties may understand just what you're saying, that means that's code for it's not worth anything, but not everybody is going to know that, and not every arbitrator is
And
necessarily going to
Right. I think that
ignore it.
in my years as an advocate, not as an arbitrator, the one thing also that's important, and this can be true of both labor and employment, is that you also have to be cognizant how you're ruling, and this is more important in labor than it is in employment. You also have to be cognizant how you're ruling, not on the substance of it, but as part of the fairness of how will that ruling necessarily affect how the advocate looks to the client. That is to say, an arbitrator, you have an arbitrator who, I'll take it for what it's worth, or I'm going to let this hearsay in even though it has no probative value and you can't cross-examine. And one side or the other will feel that, I'm talking about the principals now more than, will feel that their attorney or their business agent has lost control. And so you also want, remember, labor, as John Sands once told me when he was lowering the boom on me in a case, that, unlike employment, Jed, in labor relations, there's still a relationship after this case is over. There's still going to be a union. There's still going to be a collective bargaining relationship. And so you have to be careful.
Absolutely.
And that doesn't mean that the merits of the case are different. It doesn't mean you're going to throw it. What it means is you have to be respectful of the relationship. And I think that, in a way, is part of the reason you have to be careful about how you handle these evidentiary issues. Whether you let everything in for what it's worth, whether you let affidavits in because it's not going to make any difference, but at least the grievant will feel he got a fair shake. And these are all case by case. It's not one rule fits everything.
Absolutely.
But you have to be careful.
Absolutely. But the thing you also have to be careful of is if you allow in a lot of things, you could have parties who think, well, that's in the record. She's not deciding it based on the record.
Right.
Because I've submitted all of these things and she didn't even consider it. And therefore her decision can't possibly be fair. So again, I think people have different styles. I tend not to, certain things, as I say, they come in certain, when the grievant comes in at the end, can you tell them why you want to come back to work? Now, is that relevant as to whether or not they engaged in conduct? Probably not, but they want that opportunity. And when I get an objection to that, I sort of look at the other side and say, I think it's okay that we let them testify to that because they want to be heard.
I think one of the points with regard to hearsay, and we're not bound by the rules of evidence, of course, but they guide us, as you said, Melissa. We look to them for guidance, and in fact, they embody centuries, in many cases, of the wisdom of what is and is not reliable evidence. And hearsay, of course, is one of the fundamental principles as to what is and is not reliable, and so are the exceptions to the rule against hearsay. And one of the bases upon which hearsay under the rules of evidence can be admitted is other indicia of reliability. And so, as both of you have said, it has to be almost on a case-by-case basis. And we want to talk to the parties about why it's problematic and we're not admitting it. What is the frailty here? Or why we are admitting it and perhaps if there is frailty, the significance of that frailty, but we can't go too far until we've seen the whole record. And very often, there is some hearsay that comes in, and then through other evidence in the record, there become additional indicia of reliability that enable us to give some weight to that hearsay that perhaps initially seemed that it's so frail, it's so flawed by the absence of the declarant to be cross-examined that we can't give it weight. So it truly is case by case, context by context.
Speaking
And
of
allowing
which,
both
we're gonna
sides
move
to be
on. I'm
heard on
sorry.
an objection.
I'm sorry, Melissa?
Allowing both sides to be heard,
Absolutely.
as before you rule.
This ties in now with really the last segment as we move into the last 20 minutes, which is really one of the most fascinating and frustrating conundrums for all arbitrators is how do we assess credibility? What are the rules, if there are rules of thumb, rules of the road, especially as it relates to us as human beings with our own set of experiences and how we grew up, where we live, how we live, this thing now we call implicit bias or unconscious bias. So I'd like to start with Melissa. Melissa, what are some of the rules, some of the issues you have in terms of how can you fairly assess credibility, as opposed to arbitrators who've written, it just has the ring of truth, which is like one of the worst things you
Yeah,
can.
I have to say, I've never said that. And it is one of the hardest things that we do. Because as a general proposition, I think most people are not out and out lying. I mean, some do, we know that. We get things where people know they're lying, but there's a lot of times people are testifying to something that they in their heart believe to be true, right? And so you separating that out becomes very difficult. I do not use demeanor because people are nervous when they testify. You have some people who may have testified a million times, and then you have people who, look, they're nervous, and it shows in their demeanor, or whether they're sweating or they're afraid to look at you. I don't rely on demeanor in that respect to do it. I hate to, poor John Sands coined the term relevant demeanor, right? Where somebody is accused of being angry and nasty and losing their temper, and a good cross-examination will get them to do just that. That might be a relevant demeanor for assisting in deciding the case. I look a lot to inconsistencies. I will look very carefully at the record. I look at whether or not the individual has testified internally and consistently. If they've testified inconsistent with a prior statement that they made, you're going to look at the weight of how, did they have the opportunity to see, to hear? Did what they say make sense? Sometimes people testify to things and you just can't get there. There's no logical way that you can see that happening, as opposed to the other viewpoint that comes out that might be supported and be more logical. Those are some of the things that I would look to, but I think it's going to be inconsistencies with the record, with the documents. You have one person testifying as to one thing and you have 6 people testifying. You often don't need that cumulative, but I'm just using that as an example. As to something else, those are the types of things I look to. I do not generally look to things like demeanor. I just think is unfair because people are uncomfortable, and I recognize that. So I'm looking for other things. And, at the end of the day, if I can't decide who is more credible on an issue that is the issue, the party with the burden of proof loses. You have to move me. You have to get me, you got to move it a little bit. That rarely happens. I don't recall, but there sometimes you just walk away and you don't know. And that could be a problem as we move forward. Generally, we can figure out through inconsistencies and other things. That's what I look to most.
Jacquelin, what about you?
Well, I think the process of direct and cross-examination is a tremendous revelatory process when it comes to determining credibility, and demeanor is, as Melissa indicated, not usually a major factor in that, but rather as it relates to inconsistencies and as it relates to the testing of things like recollection and perception and even communication, because sometimes there are communication issues. And this, again, I want to get back to a comment. I received a private comment that I perhaps may have spoken negatively about non-attorney advocates, and I don't want to leave that in the session at all. I have seen superb non-attorney advocates, and I don't for a moment want to suggest that a person who is not an attorney cannot be effective. I know we all have seen many, many non-attorneys present cases in arbitration that are very skillfully presented, and they tend
Sometimes better than the lawyers.
and they know the workplace and the contract so well. And again, the questioning of witnesses is something that there's a logic to that one needn't go to law school to learn. And so I'm a real adherent to direct and cross, which is why I'm not a fan in employment arbitration. Sometimes we see the suggestion that direct examination can be presented on affidavit. I like to see the witness on both, just to allow for a little presentation in their own words, as I mentioned earlier, via non-leading questions on direct when possible. Sometimes it's necessary to lead a witness, and if you can get away with leading your own witness, then go ahead and try. And for transitional things, it doesn't matter. But we have to, I think, always be looking to the points that Melissa mentioned. There are two that I want to highlight, however, that I think we have to be very cautious about. One is the idea of interest. And I don't think you mentioned it, Melissa, but very often we hear the question of, well,
Right.
Is this witness interested? Do they have an interest in the outcome? And a lot of times we hear that this witness does not. This is a customer who made a complaint, comes to testify at inconvenience to themselves. Or this is a supervisor who doesn't really have an interest in the outcome. Yeah, I'm not sure we ever really know. Sometimes people who seem not to have any interest at all are just overinvested emotionally in a situation that may have happened. And supervisors usually do have an interest in the circumstances that unfold in a hearing. So I think we always have to be careful in assessing that. The other thing to be careful about, I think, that is critical in making credibility determinations is plausibility. Is this the way things happen in the real world? I don't like to quote TV judges, but Judge Judy defined, I think, plausibility quite well when she said to one of the people in her courtroom, "Look at me. Do you see the word stupid stamped on my forehead?" But the problem with plausibility that we as finders of fact have to always keep in mind is when something doesn't sound like that's the way things happen in real life, are we evaluating that in the context of our real life and the circumstances under which we live and operate and exist? Because that witness may exist in a world in which what they're saying might be plausible. And so for advocates, I like to say, keep that in mind always. If there's something that is perhaps in need of a little explanation for the arbitrator to understand the plausibility of what's being said,
And
that is something
brings
to
us
develop.
to some of these, psychologists have been doing a lot of work in this area of how to, watch ourselves, because are we looking at things through our own context? Certain cultural biases that we bring with us from our own particular culture. There's this thing called the affinity effect that I think we talked about the other day, where decision makers are influenced by their own cultural backgrounds. So, like you said, something seems inherently implausible to me, but that's only because of, we have to go a little deeper, and it's important for us to know that. The expectancy effect is similar to the confirmation effect, where, we expect the world to act in a certain way. And so and it may, but I think we have to try to understand the way that the world works in that workplace with these people, not with us. And there's something that I've been reading a lot lately, and there are what's called credibility discounts and credibility inflation, where we tend to credit some people more because of either they're stationed or how they're dressed, and we tend to discount credibility based on their status or whatever. I remember for many years, I used this quote because I found it in a case, an arbitration case, where an arbitrator made a credibility finding on the basis that it was more likely that the grievant would lie because he lost his job than the supervisor. Now, of course, as I matured and, you know, I tried that quote with John Sands. Again, we quote him more than anybody else. And, but the truth is, as we mature and as we learn more, we understand that a grievant is not more likely to lie than the supervisor. But the point is that, and we find that not just, right, but I do a lot of harassment investigations, and, you know, you get these different power dynamics. We're not going to change it, but if we're aware of it, you know, before we make that finding, we can try to understand why we're crediting the person. That's really the key. And I realize this is sort of wonky, but this reminds me, most of us who went to law school have been taught, at least in law school, and that extrinsic evidence can only be used in a contract case if it's unambiguous, unless the contract is unambiguous. It has to be ambiguous. And that seemed to be what the rule was, but that's not the rule. Say, for example, in New Jersey and the Third Circuit. What the Third Circuit said in a case was, wait a minute, just because you, district court judge, think that the language is unambiguous, how do you know it's unambiguous in light of their experiences? Right. Your experience of being an upper middle class Jewish guy living in Parsippany, New Jersey, may not be the same as how the parties understood this contract language. So therefore, you got to take the extrinsic evidence, review it, to then decide whether it's ambiguous or not. And that's how I view the credibility discount and the credibility inflation and all these biases, which is we sometimes have to step back and ask ourselves why we are crediting this person or not crediting that, beyond the obvious, like, well, they lied on the stand, you know, that kind of stuff.
There's also something that as you're assessing a case, you have to keep in mind that the people who are testifying before you have their own biases.
Right.
And sometimes they are making judgments based upon some cultural idea or their vision of it. And they may find something, for example, to be very offensive that another person truly, you know, I didn't mean to offend. That's just the way we talk. That's the way we deal with things. And you know, I mean, if someone is offended, it depends what it is. But my point is that implicit bias is something we need to be careful of in making decisions. Right. But we also have to recognize that sometimes the witnesses who are making decisions also have implicit bias that they don't really know or understand. I mean, they're testifying genuinely as to what they believe, but is that because of their own implicit bias? And that's not even, I'm not even talking about it being a discrimination case. You know, a case, for example, where certain slang is used or where certain music was listened to that wound up, you know, had curse words in it, and someone overheard and they're fired for it. And, you know, they didn't mean for that to happen. They didn't mean to offend. Those are things you have to keep in mind as well. Not to say you can come into the workplace and play loud music that has curse words in it all the time. But you understand what I'm saying. You've got to keep that in mind as well, because it's not just us, it's everybody.
Well, before we open up the last 6 minutes
can I just add one comment about making...
Take as much time as you want, Jeff.
Just about making credibility determinations that follows on what you both have said. And that is that, you know, we are constantly checking ourselves for bias, for noise, you know, those things. Are we reacting kind of skeptically toward this witness because there's something nagging in the back of our minds unrelated to the case? You know, we have to always be auditing ourselves. And one way to help guard against the effect of these biases that we may have, or noise is a popular term right now in light of a new book, one way to do that, of course, is to make sure that we reserve judgment until we've heard everything, and also something that we do in labor and employment that is not as common in other forms of arbitration. In commercial, for example, is giving the written findings of fact. Because sometimes it's when we pour through the record and we start writing the facts and we start putting together on paper what we think happened and why we believe this account as opposed to that account, that we can see things with perhaps a little bit more of a separation than we even have in the moment when we're striving for that separation, but we're still in the moment hearing the testimony.
Before we open it to questions, I just want to recommend which ostensibly have to do with sex harassment, sexual assault, and issues related to investigations, but they were really very helpful to me in terms of as both an investigator and as someone who's interested in how do I determine credibility in a fair way. And one is called Sexual Justice by Alexandra Brodsky. Again, not technically about arbitration, but a lot in here about how to assess credibility and what kinds of mistakes we make. And then a book called Credible by Deborah Turkheimer. Again, she was an ex-prosecutor. Again, really about issues related to sex harassment and assault and procedures, but a lot of good information and a lot of good thought-provoking discussion about credibility and how we make mistakes in credibility and how we create a level playing field, whether it's in an investigation or in an arbitration. And we got just a few moments left before Lara comes back. So does anybody have any questions or comments of any kind? No?
I have a question.
Yes.
I'm a new arbitrator, and usually in hearing a case, I kind of get a sense of where it's going after the hearing. I was wondering how the panelists feel about, do you have that feeling that kind of leads me one way or the other in analyzing the case? I was just wondering how you handled that.
I would say that yes, I do. After most cases, I do have a sense of where I'm going, but as Jackie said, I tend to, when I write, if it doesn't flow, it means I got to go back and look because there's something that's not there. I may have walked out thinking one thing, but as I go through the record and try and put it down, I can't get from point A to point B, which is what I was thinking before. It doesn't happen often, but it does happen. And when it does, I have to step back and say, maybe my first, my impression having heard everything was false and it wasn't the right thing. And, or it might go to the remedy or how extreme, but that's something that the writing process, I think, does help me confirm it, but I generally do walk out having a sense of where I'm heading.
Jacquelin?
Oh, we can add another quote. John Sand's good friend and your co-author, Melissa, Norm Brand, says, "If it won't write, it's not right."
That's right.
And I'll tell you, because exactly that. I did an arbitration where I had a sort of an impression, and then as I started writing the case, and I would ask myself, well, I got to go back to my notes because I remember thinking this, but I don't think there's any support for that. And I had that experience in a case where there was a transcript, and whereas in the hearing, I felt very sure that this person really knew what they were talking about. But then when I went back to the transcript and read the examination and the cross-examination, everything she said in the exam direct, she basically walked away from in the cross. And all of a sudden, who I thought was a very important witness was not an important witness anymore. So the answer is, it's important to not go with your first impression. It may be the right one eventually, but you got to think it through. And if it don't write, it don't write.
Yeah.
Anything else?
Well, I'll make one quick comment on what to be expected on both sides, and that is be responsive to each other. That's part of being respectful. You know, if I get something, I try really hard to get back the same day or within 24 hours to at least acknowledge it. And I sort of hope that the other side, you know, that the advocates will do that as well, so that we can keep things moving forward. And sometimes that, on both sides, I'm sure that happens, but being responsive is a really important part of making it an efficient process. So that was something I hadn't raised before. Anyway.
And we never really talked about how important the award, you know, how we write the award is, but that's for another day, I guess.
It is.
Yes.
Okay, thank you so much. all.
Thank you, everyone.
Bernadette is back, so I guess that means it's time for me to click on the leave button, and we can all say goodbye. Thank you so much, and Melissa and Jacqueline, we'll talk next week.
Okay.
We
That's
will.
Bye.
great.
Thank you.
Thanks.
Thank you,
Safe
everyone.
travels back home, Jacqueline.
Thanks so much. Thanks, Melissa. Thanks,
Take
Jack.
care.
Bye.
Bye, everybody.